Good afternoon, everyone. I'm Mary Kate DeLuco, Communications Consultant with Death Penalty Focus. I'm here with my colleague Yoko Otani Sperlin, who is the Business and Finance Director at DPF, and she's keeping everything running on this webinar. I'd like to thank you all for being here. We're observing World Day Against the Death Penalty, which is today, with our webinar, the torture of solitary confinement. We're very, very excited about the guests we have with us today, and I'm going to turn the webinar over now to DPF President Mike Farrell, who will introduce our guests and begin the discussion. Mike.
Thanks very much, Mary Kate. And hello to all of you people from many time zones all over the United States and in parts of the rest of the world. In honor of the victims of what's going on in the Middle East, let me just say that all of our hearts go out to everyone who is involved in this terrible, awful experience. My name is, Mary Kate said, is Mike Farrell. I'm president of the board of DPF, Death Penalty Focus. And today is the World Day Against the Death Penalty. This is one of a series of webinars we offer on ending the death penalty and other related subjects, exposing the cruelty and inhumanity in our criminal justice system. Today, as Mary Kate said, we're focusing on solitary confinement. And I can't think of two people more knowledgeable about the issue of solitary confinement than our two guests. Rachel Mirapol, currently a lawyer with the ACLU, Rachel represented people imprisoned in solitary confinement in California in the landmark lawsuit Ashker versus Brown, when she was a lawyer with the Center for Constitutional Rights. That lawsuit effectively ended long-term solitary confinement throughout California state prisons in 2015. Or did it? And Juan Mendez, currently a professor of human rights law in residence at the Washington College of Law at American University, was the UN's special rapporteur on torture from 2010 to 2016. In that role, Juan traveled the world investigating and reporting on the use of torture in UN member states. In 2011, he defined what constitutes solitary confinement and the effect of prolonged solitary confinement for the first time. So welcome both Rachel and Juan.
Thank you.
Rachel, you represented incarcerated people at Pelican Bay Prison in Ashker versus Brown. Juan, you served as an expert witness in Pelican Bay litigation. May I assume you two have met or at least are aware of each other?
Oh, absolutely. I've been following Juan's amazing career for years.
As have many of us.
We have met.
I'm sorry, Juan, go ahead.
No, I think we have met, but it's good to see you again, Rachel.
Yes. Well, I want to thank you both for being here. Both of you have advocated and worked for many years to abolish the torture of solitary confinement. So I'd like to ask each of you, how does solitary confinement qualify as torture? And what are people or organizations doing to end it? I guess what I'm asking is, what is the definition of torture? Is it psychological, physical, emotional, or all of the above? And I'll let each of you pick up on that question.
Well, the definition is in the Convention Against Torture, an instrument from the 1980s that, in fact, the United States has signed and ratified. And most of its provisions have become customary international law, and the prohibition of torture and of cruel, inhuman, and degrading treatment are beyond customary international law. They are imperative norms of international law that bind all states in the world. And the definition includes both physical and mental torture, what we would call psychological torture, but that's what the convention says. And it is physical or mental pain and suffering of a certain severity that is done deliberately in the case of torture, but it could be by negligence in the case of cruel, inhuman, and degrading treatment by a state agent. We also include torture inflicted by non-state agents when the state is aware and ought to do something to prevent it and doesn't act. But by and large, it is a state agent that has to either commit the torture or acquiesce in it or tolerate it. In the case of solitary confinement, well, I'll let Rachel complement what I said about the definition, and then we'll get to when and in what circumstance solitary confinement steps into the definition of torture.
Thank you, Juan. Rachel?
Yeah, well, I agree completely on the definition that Juan has shared as being definitive. And I think if we look at, how solitary confinement operates, we have to start from the understanding that human beings are social animals and that we need interaction. We make meaning in our lives through our interaction with others. So it shouldn't be a surprise to understand that deprivation of that interaction causes severe psychological pain, but also physical impacts as well. Decades of studies have shown the impact of solitary confinement on mental health, the way it increases the risk of suicide for individuals who are subjected to it, as well as other forms of self-harm, leads to sort of psychological and emotional symptoms. Prisoners who, are subjected to prolonged solitary confinement experience something that, researchers have termed a form of social death that is not cured upon release from solitary confinement, but rather sort of lingers as a syndrome characterized by sort of increased self-imposed social withdrawal and anxiety and isolation. Maybe a bit less well known are some of the physical impacts of solitary confinement on human beings. But we know from some of the other experts we worked with in the Pelican Bay case that, prolonged solitary confinement causes hypertension, which comes with sort of serious physical health consequences for individuals. And studies have also shown how sort of the pain caused by isolation actually appears in the brain the same way that physical pain sort of lights up areas in your brain. So this pain being experienced cannot be, simply discarded as sort of psychological pain. It comes with physical pain as well. I'd also just add that, in the context of the death penalty, I think one aspect of solitary confinement that is especially devastating is its indefinite nature. The fact that individuals cannot look to any period of time when they might be sort of released from this form of torture.
God, the concept of social death is chilling to the core. Perhaps to clarify for me and others who have this question, what is the difference in your view, each of you, between solitary confinement and single cell confinement? Or is there a difference?
The solitary confinement was defined originally in a lesser known instrument of international law called the Istanbul Statement on the Abuse of Solitary Confinement. It's a document from 2007, I believe. And it doesn't really say that solitary confinement, is restricted to, being alone in the cell. So there may be some possibilities of solitary confinement in pairs, for example, that if they're prolonged enough, they could, constitute solitary confinement anyway. But in general, we talk about solitary confinement by when we mean that someone spends 22 to 24 hours a day alone in a cell. And it doesn't matter if it's in a dark and damp cell or if it's in a relatively decent cell. It's the loneliness, it's the isolation that really constitutes solitary confinement. And And in fact, it doesn't even matter if in those remaining 2 hours, if there is a remaining 2 hours, the person goes out and exercises, because generally, like in Pelican Bay, they also exercise by themselves, each prisoner. So this, cutting off from meaningful social contact with others also defines solitary confinement. It also doesn't matter if guards, for example, or prison personnel, even treatment personnel, have access to the person, because when we talk about meaningful social contact, we mean social contact of the person's own choice, meaning, for example, other people who are detained. We also have a more recent and better known instrument, the Standard Minimum Rules on the Treatment of Prisoners, that has it's from the 1950s, but has been amended several times. And in 2015, it was amended to include regulation of solitary confinement. And it specifically prohibits prolonged or indefinite solitary confinement, like Rachel mentioned. And prolonged is defined as anything beyond 15 days of this kind of regime. But it also prohibits solitary confinement, even of short duration, for children, anybody under 18, for people with any psychosocial disability, including temporary psychosocial disabilities, if the confinement is going to make the symptoms worse, and pregnant or breastfeeding women. So now we have an international regulation of solitary confinement through the Nelson Mandela rules that is much more precise. Unfortunately, until 2015, there was no clear regulation of isolation. And as you can see, there are some legitimate uses for isolation, for example, for disciplinary purposes, if it's a last resort, if it's accompanied by due process standards, so that no one is arbitrarily put in solitary confinement, and especially if it doesn't go beyond 15 days.
And just to add to the sort of common sense understanding of why confinement in a cell with another human being can still be seen as solitary confinement, despite the fact that one is, not alone exactly. If you think about what it must actually be like to be trapped in a small space, cut off from all voluntary communication with another human being, but isolated with another person, sharing that same space with that other person during all that period in which you're cut off from the other world. Those types of interactions become so loaded and problematic when individuals have no ability to, step back and get time on their own, that what we see from talking to people who have experienced solitary confinement, either in a single cell or with another human being, is that we see a lot of the same impacts on their mental and physical health because of the fact that normal human action is completely off limits to them.
That may explain something I was deeply troubled by in Oklahoma. I was involved with a couple of cases, and in Oklahoma, they have two death penalty convicted, condemned prisoners bunking together without, as I understood it, a way in which one of them can raise an alarm and call for help.
And, a lot of states will do this to avoid acknowledging that they are engaging in solitary confinement. I mean, if you look at the California Department of Corrections website today, under sort of its FAQs, if there's a question, is there solitary confinement in California? And The answer is just a flat no on the website with no explanation. And of course, that no would be of surprise to the thousands of people in solitary confinement in California who are still experiencing this form of torture. But the state, will call it by a different name. We'll say, oh, this is restricted housing, not solitary confinement. This is segregation, not solitary confinement, while at the same time not bothering to define why it thinks the way it's treating people shouldn't qualify.
And the Nelson Mandela rules actually say that no matter what it's called, the solitary confinement is defined the way we define it. So what the prison authorities call it is meaningless. It's really what the objective, form of treatment, what defines whether we are in front of solitary confinement or not.
Well, excuse me, Juan. I know you. We are longtime friends, and I know you were arrested in your home country, Argentina, in the 70s for having had the audacity to defend dissidents and others the government didn't favor, and that you were held in solitary confinement and tortured. Later in your work as the UN Special Rapporteur on Torture from 2010 to 2016, you investigated and reported on the use of torture in the 193 UN member states. And pertinent to the subject at hand, internationally, the US in general is an outlier, is it not? You traveled the world to investigate prisons and the use of solitary confinement. You were admitted to prisons in Mexico, Tajikistan, Sri Lanka, many other places. But the United States, as I understand it, wouldn't give you prison access. Is that correct?
That's right. They did invite me, but on conditions I couldn't accept, because the special rapporteur on torture is basically the rapporteur on prison conditions. So if you don't insist on being able to visit prisons and the prisons of your choice, and to visit every part of the prison, and to talk to whoever you want to talk, and particularly that no one is going to have adverse consequences for talking to you, you really cannot accept. You can imagine if I accepted conditions of that sort from the United States, every other country would tell the next special rapporteur that they would give similar treatment. I actually asked for permission first to go to Guantanamo, and they didn't give me. They invited me, but they said that I could only be given a guided tour, and one particular term of reference was that I could not talk to anybody there. So I said, no, in those cases I can't go. But then I asked to go to prisons in the mainland, particularly to look at solitary confinement. And then they asked me which states, and I listed 6 or 7 states, and one by one the states declined to invite me. And then the Federal Bureau of Prisons did invite me to go to Florence, Colorado, to the ADX, as it's called. And they also told me, yes, you can go, you can talk to anybody, at least within eyesight of the guards, but you can talk to anybody except those accused of terrorism or convicted of terrorism. And again, that was something that I could not accept. So unfortunately, I was not able to go, even though I insisted for 6 years to come to the United States and to do visits the same way I did it in so many other countries. I have to say that the United States is not the only country that doesn't invite, but it was particularly complicated in this case because I was trying to look at solitary confinement precisely.
Rachel, have you had similar experiences?
Well, during the course of litigation, prisons, can't keep us from speaking with the individuals we represent, and that they can, of course, dictate the terms of that communication. And that is something that we did a lot of work around in the Ashker litigation, which I think was a real important aspect of why that case was so successful. And I should back up and say that really the Ashker case came out of organizing by individuals that was happening inside the prison, inside Pelican Bay Prison in California, which is one of the most notorious sort of solitary confinement prisons in the country. And individuals from inside solitary confinement were sort of organizing across racial and ethnic lines to form what they called the Prisoners' Human Rights Movement, to draw attention to solitary confinement as a human rights violation, as torture. The Ashker case arose out of that movement as sort of a piece of litigation intended, not just to challenge solitary confinement in the courts, but to serve as a vehicle to advance the aims of the organizers of the Prisoners' Human Rights Movement. And to be able to do that successfully, we, the legal team, really needed to be able to talk to our clients constantly. There's a lot of decisions that have to get made as a case is moving through the courts. And when lawyers become the sole decision makers, lawyers who have not experienced solitary confinement, don't understand what's happening inside the prisons, don't have access to those essential facts. The case can become unmoored from sort of the goals of that it started with. So one of the first things that we did when the case started was move the court for telephone access to all the class representatives in the case. And at that point in Pelican Bay, individuals in solitary confinement there weren't allowed any telephone access with family, with lawyers. It was one of the ways in which the prison was sort of different from a lot of solitary confinement regimes across the country. The only time individuals inside could communicate by phone with the outside world was when a loved one was about to die or had died. So our clients had gone, decades in some cases with, perhaps a single call to a family member to learn of a family member's death. We explained to the court that we could not represent our clients effectively without being able to communicate with them by telephone consistently, and won the right to have 1 hour phone calls every other week with each of our 10 representatives. And that was a huge part of being able to move the case forward in a way that reflected their changing goals for the litigation and ensuring that they were really a part of sort of what we were building through the lawsuit. There was a second time in which communication played a huge role here. When we finally got into settlement negotiations with the state, we explained that our clients needed not only to speak with us individually, but to speak with each other about what they would be willing to settle the case for, and to together come up with, new rules that California would have to be willing to live with in order for us to agree to settle the case. That it could not be that lawyers would act as intermediaries, each one of us calling one of them, sharing the information, bringing it back. This was, a movement that these individuals had formed together in sort of a unified way, and that they needed to communicate with each other to formulate a settlement demand that they would be able to live with.
It's remarkable. Well, so solitary confinement and the death penalty are, I think, inextricably linked. It's a common practice in the U.S. to hold people on death row in solitary confinement, which most countries now recognize as a form of torture. But a recent study, as I understand it, found that in 2020, 12 states automatically housed death sentenced prisoners in indefinite solitary confinement, in violation of the UN's Nelson Mandela rule that Juan just mentioned, the rule that calls for, and I quote, to restrict the use of solitary confinement as a measure of last resort, to be used only in exceptional circumstances. Where is the is there any kind of pressure being brought to the various governments and our own and the states to adhere to that restriction?
Well, yes, there is, and on the occasion of the World Day against the death penalty, it's very pertinent that Death Penalty Focus has decided to talk about solitary confinement, because, as you say, Mike, it's intrinsic to the whole process of capital punishment, that solitary confinement is part of the process. And it's in those cases it's always indefinite and always prolonged, and it is intrinsic to capital punishment because I mean I've in my capacity as special rapporteur I found out that in other countries that are retentionist and maintain capital punishment. In many countries, it's the data is just not there. It's difficult to know, but it's not only in the United States that solitary confinement is part of the process of capital punishment, and by definition, it's indefinite. And as Rachel pointed out, it adds an additional ingredient of anxiety and of uncertainty about one's fate that. It's very easy to understand that that's pain and suffering of a very severe kind, mental, yes, not physical, or maybe physical also, but even if it's only mental, it's still prohibited by the Convention Against Torture. And in addition, it has to be very prolonged because the international law does require for capital punishment very stringent due process guarantees. For example, the ability to contest evidence, the ability to be represented by an attorney of one's choice. The decision has to be made by an independent judiciary, and also there has to be all kinds of appeals because the death penalty is so final. The international law, although it doesn't prohibit it outright, although the trend is towards prohibition, but if it doesn't prohibit it outright, at least it establishes a certain measures of due process that are very stringent and that result in prolonged solitary confinement. Now, obviously, technically, it could be possible for people in death row to be not in solitary confinement, but in practice, as I said before, not only in the United States, but almost everywhere that retains a death penalty, the death row phenomenon is a phenomenon of solitary confinement.
Rachel, I have to say, listening to what you talked about in terms of the death row prisoners for human rights or whatever they called themselves, the ingenuity of human beings, even under the extraordinary circumstances we're talking about, is really quite amazing that they could organize and that get the word out to you so that you had the understanding you did that what you could demand, that you could demand what you could demand. It somehow fulfills me with hope that the positive aspects of human life can, in fact, prevail over the grievous restrictions and punishments that organizations and governments levy. The watchdog group, Solitary Watch, Rachel, and the advocacy coalition Unlock the Box released a joint report called Calculating Torture in May, showing that at least 122,840, almost 123,000 people are locked daily in solitary confinement in the United States prisons and jails for 22 or more hours a day. Now, this is, I understand it, this is the first report to combine the use of solitary in local and federal jails in addition to state and federal prisons. How is it that it's so difficult to convince the states and federal government to adhere to the Mandela rules?
Yeah, states cling to solitary confinement like other forms of control, insisting that it is the only means to protect individuals inside prisons and correctional officials, when actually the evidence shows that solitary confinement does not decrease violence within the prison system. In fact, it's the opposite of solitary confinement that decreases violence in the prison system, giving individuals who are incarcerated, positive opportunities to socialize, to program, learn skills that will aid their rehabilitation. This is what we know decreases violence. And yet we see so little movement within prison systems. I will say, I think there's been a remarkable move away from solitary confinement and a remarkable new awareness of the issue in the last 10 to 20 years. It's hard to imagine another sort of criminal legal system issue where I think we could see such positive movement. Still so much more work to be done, but lots of states finally recognizing that solitary confinement is a form of torture and beginning to reform their prisons under, with the objections of the correctional officers unions and prison administrators, of course, the whole way.
Well, to bring this issue home for at least some of us on this call, despite being considered one of the most progressive states in the country, California is an outlier in its use of solitary confinement, isn't it? I read that until Ashker, Rachel, California imprisoned more people for longer periods than any other state, which is hard for me to believe. And we're talking about total solitude, 23 to 24 hours a day for more than 10 years.
Yeah, that's right. As of 2012, which was the time that the Ashker case started, there were more than 500 people, which is about half the population of the Pelican Bay Solitary Housing Unit, that had been there for more than 10 years. And there were 78 people that had been there for more than 20 years. I mean, can you imagine 20 years in solitary confinement? And, you might expect that someone in solitary confinement for decades would be there, because of an act of extreme violence. But what we actually saw was that California imposed extremely prolonged solitary confinement based merely on individuals' alleged association with a prison gang. So for many people, this was about political activity inside prison. For example, people ended up in solitary for decades based on nothing more than possessing Black Power literature. The California identified what it called the Black Guerrilla Family, which is a radical prisoner organization inspired by the writings of George Jackson, who was killed by prison guards, as a violent prison gang. And just by reading George Jackson's book or other political literature, that meant that California considered you a violent gang member who could be placed in indefinite solitary confinement. I think I need to stop talking for a minute so I can have a little bit of water. So I'll pass it over to you, Juan.
Well, in my experience with the Ashker v. Brown litigation, I was put first in a BBC broadcast with a high prison authority in California, and this person said, "No, it's not torture because the minute any of these persons show any signs of psychological problems, we just take them out from there." And unfortunately, the BBC allowed him to get away with something like that. But then when I interviewed the named plaintiffs in the class action of Ashker v. Brown, one of them told me something that really has resonated with me ever since. He said, "We cope, but the fact that we cope doesn't mean that we don't suffer." And so the whole idea that it's not torture because this person can survive the pain and suffering is looking at it the wrong way. It's still pain and suffering. Just like I can be very sturdy and get beaten, but if I get beaten, I'm beaten. I am still experiencing deep pain and suffering. And as Rachel was saying, we were talking here about people who have been 10 years or more in solitary confinement without any due process, without any clear definition of why they should be there. And what really is troubling is that the federal courts had, until then at least, refused to intervene because it was not the solitary confinement was not branded as a disciplinary action, and therefore it didn't affect. It was prison management, quote unquote. So prison management was not the purview of federal courts because it supposedly did not affect the rights of a person deprived of liberty. Now, of course, it did affect the rights of persons deprived of liberty, but just labeling it prison management had allowed these cases to go on and on without serious intervention by the federal courts until the excellent work that the lawyers for Asher v. Brown did, and as you know, succeeded in getting a consent decree that, at least temporarily, and of course it's not the end of the story, but at least temporarily had an enormous effect. I think 90% of the people in solitary confinement walked out of those 22 to 24-hour cells.
Yeah, and Juan, just as Juan has mentioned, I hope you've had a chance to get a little water, Rachel. Juan said that's not the end of the story. What happened after Asher?
Yes. Well, so Juan is exactly right. The consent decree, the settlement succeeded in ending really indefinite solitary confinement in California. But of course, that's, whenever the prison system, has one tool taken away from it, we have to watch closely to see, what's going to happen next. How will they, continue to exert power after they've been forced to make a change? So we monitored the way individuals were sent back to solitary confinement after the initial wave of releases, and uncovered the fact that dozens to hundreds of people were being put back in solitary confinement for prison rule violations. So under the terms of the Asher settlement, individuals could not be put in indefinite solitary confinement for alleged gang affiliation. However, California could still use disciplinary solitary confinement. Our settlement cabined it to the most serious disciplinary offenses and cabined the time period individuals could be held in solitary confinement for those prison rule violations, but it did allow that confinement to go forward. So we began to look at the cases, each of the cases in which an individual was sent back to solitary confinement for these prison rule violations, and found a pattern of California fabricating confidential information to use as an excuse to return individuals to solitary confinement. So, this is, it looked like prison investigators telling an individual that they had been, for example, identified by a confidential informant as an individual who attacked someone, tried to kill them on the yard. And then we would go and look at the actual confidential memorandum that was supposed to recount what this confidential informant had said, and find that actually the confidential informant identified someone else, not the prisoner in question. So just blatant fabrications in case after case after case. And by showing a pattern of these fabrications, we were able to convince the district court judge in the case to extend the court's jurisdiction over sort of what California was doing to enforce the Asher settlement for many, many years. And right now, the Ninth Circuit is considering whether to rehear a decision that we just received last month from the appellate court, finding that these kind of confidential information fabrications, alteration of evidence, doesn't violate the due process rights of people in prison. And that, which would, if not revisited, the decision would allow California to continue sort of getting around the restrictions on solitary confinement by misusing confidential information in this way. So, I'm sort of on pins and needles all this month, waiting to hear what the Ninth Circuit Court of Appeals decides to do.
Oh, God. And a bill to abolish solitary confinement passed the legislature last year, but was vetoed by Governor Newsom. Newsom vetoed it because he said it was too expansive. I'd like to know more about that. CDCR said it was too expensive. A similar bill was pulled in the final hours of the legislative session that ended last month because of a likely veto from Governor Newsom again. And then just last week, the California Department of Corrections and Rehabilitation announced new rules for solitary confinement that are hardly impressive. Reducing the number of offenses that can send a person to solitary confinement is fine. Limiting the offenses to acts of violence and threats of violence or possession of weapons. But they set no time limits on how long a person could be confined in solitary. Any thoughts about that?
Well,
I
of
can
course,
start.
go
Go ahead,
ahead.
Juan, please.
No, I think I just want to say that if it would be better for the law to put some limits on solitary confinement, and hopefully that they would be in compliance with the Nelson Mandela rules. That is, 15 days, more than 15 days is always prolonged solitary confinement. And also that there couldn't be repeat. For example, many countries have shorter terms for solitary confinement, but the terms can be repeated indefinitely. There has been litigation in Canada that has been very successful, and the Canadian government is, changing its regulations on solitary confinement to comply with the Nelson Mandela rules. And the same without litigation in Ireland. Ireland was the first country already in 2017 to amend its prison regulations to prohibit solitary confinement within the strictures of the Nelson Mandela rules. So, and as you know, New Jersey has abolished solitary confinement. So this is going to be a very long process, but it's important to start precisely because it's going to be long.
Yes, indeed. Do you have any sense, Rachel, of what to Governor Newsom too expansive means?
Well, I guess I can't really speak for the governor, but what I can say is that I take a lot of solace from the fact that, the advocates in California who have been pushing these reforms are absolutely tireless and informed by sort of what the folks inside are asking for, and an amazing group of sort of family members of individuals who've been held in solitary confinement, who are just doing remarkable organizing around the state. And I think their message to the governor is that, we are not going to rest until we see real change. And, some nibbling around the edges about the ways the state uses this form of torture is simply not going to cut it. One thing that I have also been really happy to see is legislation at the federal level that is really aimed at ending solitary confinement altogether. Congresswoman Cori Bush introduced a bill this year called the End Solitary Confinement Act, which is an incredibly far-reaching proposal to truly end solitary at the federal level and to incentivize the states to do the same. And so we're seeing now, more and more far-reaching attempts to really rein in this form of torture. And until California gets with the program and makes real change, it is going to be confronted with these efforts.
Well, this is all very disturbing, I have to say, but to end, if you will, on a more positive note, what can you suggest? What do you think are the most important steps we can take as individuals and advocacy organizations to raise awareness that, just like the death penalty, solitary confinement is yet another example of the inhumanity, the barbarity in our penal system, and then use that knowledge to work together to get it abolished here in the United States?
think one of the most essential things for us to focus on as we do this work is to use it as an opportunity to create a platform for people inside who are organizing around this issue, as well as sort of the people who in their family who are directly impacted. This is what led to real change in the Ashker case, the fact that litigation was undertaken hand in hand with real organizing inside. And it's only through ensuring a lot of communication with people who are experiencing solitary confinement or have experienced it that we will understand how to make true reform. And that means not just, being in community and in struggle with folks inside, but also focusing on the barriers to communication, working to improve access to people in prisons, sort of across the board, regardless of whether they're in solitary confinement or not, so that the issues that are of importance to people inside can be shared out in a more robust way with those of us doing advocacy on the outside.
Juan?
Well, I think we have seen progress, such as it is. I mean, it's slow, but very clear progress on the abolition, both de jure and de facto, of the death penalty itself. I mean, the countries and even the states that retain the death penalty within the United States are shrinking, and it has to do with renewed consciousness around the world of the barbaric nature of capital punishment and of solitary confinement. So I think we need to continue to campaign, and I hope that instruments of law produced by the international community can be of assistance to those campaigning inside prisons and outside prisons, their lawyers and their families, to produce the change that we need. The abolition of prolonged or indefinite solitary confinement and the abolition of capital punishment. I think I'm glad that you mentioned, Mike, earlier the report by Unlock the Box, because I with another hat of the United Nations, the independent experts mechanism on racism and law enforcement that I'm a member of, I visited the United States. This time I did visit prisons, and I actually visited Cook County Jail in Chicago and the Los Angeles County Jail in Los Angeles as well. And just to confirm what Unlock the Box says, completely at random, I run into a young man who was in solitary confinement in Los Angeles County Jail for like 7 or 8 years. And supposedly because it was a complex case, hearings get postponed, there are multiple defendants, so they don't take them back to the penitentiary. But the conditions of solitary confinement in county jails are even much worse than in the penitentiaries, because they're really dark places, narrow places. There's almost no opportunity even to go out to exercise, even for the 1 hour that some prisoners are allowed to have. So bringing the focus into county jails is very important as well, because solitary confinement is being abused in many different ways, and I think we are in a position to campaign effectively for for regulation of it, as we can and should continue to campaign for abolition of capital punishment.
On a personal note, I wish I'd known you were in Los Angeles. I'd love to have caught up with you.
It was a very quick trip.
I'm sure.
I'm sorry, I should have called.
No, it's okay. Mary Kate, do we have questions from any of our audience members that we can?
Mike, I'm happy to say we don't, at least that I can find, but and the only reason I'm happy is because we promised Rachel we'd get her out of here on time for her next meeting.
Okay.
And we will be able to keep that promise now. So, but I just want to throw in one really quick thing, and that was Juan, I believe you were responsible, or at least mainly responsible, for the Canada's new regulations. In my research, I came across a reference to thanks to you for the Canada. So that is correct.
Oh, well, I was expert witness there, like I was in Asher Brown, but in 3 different class actions, and all 3 of them, the Court of Appeals declared the existing rules at the time unconstitutional because they were against international law. But I was just one. The lawyers, the Canadian lawyers, really deserve the credit for it. It's a great litigation.
I read you deserved a great deal. So either way, I did want you to get recognition for that.
For both of you, I can't tell you how much your heroic efforts and your dedication mean to those of us who are on the outside looking in and feeling the pain and grief and embarrassment at the association with what we call a criminal justice system in this country and around the world. Juan, you, of course, are dealing with issues, and you as well, Rachel, because I think what the United States does in so many instances can be an example for good. But in this instance, we are retrograde actors, and I find it to be pathetic and embarrassing, I must say, in these instances. But I can't thank you enough for taking the time to be with us today. I know you have a meeting to go to, Rachel, and Juan, I'm sure it's probably time you should be sleeping.
Bedtime, yeah. I really appreciate the invitation. It's been a great honor as usual, and especially to share the panel with Rachel.
My sentiments exactly. So wonderful to see you, Juan, and thank you so much for all the incredible work that you are doing.
Thank you, Mike, and Mary.
Thank you very, very much.
Thank you both.